This is Greg Remke with Economic Thinking, and this is the presentation for the University Interscholastic League on the National High School Debate topic on intellectual property rights. Resolved, the U.S. federal government should significantly strengthen its protections of domestic intellectual property rights and copyrights, patents, and/or trademarks. So, from the National Federation team that did a research on this topic and proposed it, I'm reading their text. It's in italics to show these aren't my words, but theirs. The importance of intellectual property rights stretches across all areas of American life, from the technology we use to the pharmaceutical drugs we rely on, the entertainment industry. Intellectual property rights have been part of the U.S. innovation policy since the country was founded. Its relevance in our day-to-day lives. Look at the rise of AI-created art, drug prices, Taylor Swift's albums and versions. There's not a single good or service that we enjoy in our daily lives that is not in some way shaped or affected by the protection of IPR, intellectual property rights. Again, this is the advocate saying that this is really important and students should strengthen it through their affirmative cases. So the proposed resolution asks affirmatives to strengthen property rights in one of three areas of IP law: copyrights, patents, and trademarks. So I link here, and you should be able to, in the PDFs, link on the URL there, and you'll get a quick segment from the Modern Family Show where Gloria finds out that her grandmother's recipe for a sauce has been copied by a commercial company, and she stole the sauce recipe, Gloria claims, and the lady says, you know, who's your patent lawyer? That is, if you create this great recipe for a sauce, you think it's yours, but unless you own it, unless you've patented that formula, anybody can take it from you and call it theirs. And that's a discussion, and she says big corporations are doing this all the time because everyday people with inventions don't have the money to protect themselves from these, greedy corporations taking their stuff. I mean, this is a TV show. This isn't high-level academic literature, but it gives you a flavor of what's going on, according to critics, at least Hollywood critics. But an alternative approach might be that this is the sauce is a recipe, and we're always tasting other people's food, their sauces, thinking, how did they make this? Could we improve it? Is there another way to protect intellectual property that is the secret sauce? And the argument is, yeah, you hire a company to make it, and they sign a contract, a contract that they've got your sauce formula, but they can only make your sauce with it. They can't sell it to others. And if you find they have, you can litigate on that. But it's a contract-based approach to protecting intellectual property rather than the status quo, having the federal government do it. Remember, the federal government isn't protecting your rights directly. It's actually stopping someone else from doing something that you claim they shouldn't do because they took an idea or a formula or a patent, something from you. So I play the video here. I'm going to skip over it because of intellectual property concerns on who owns it, but you can find it on YouTube. But there's a debate about owning ideas. It's one thing to own your own car, your house, but what does it mean to say you own an idea? A joke, for example, or a sauce for a recipe, or a rocket like Elon Musk's SpaceX rockets. Does he own the technology that he developed to fire those rockets? Well, you can look it up. And he says, well, we've not patented anything. We've drawn from other people. We're promoting these ideas. We think it's really, really complicated to actually carry out the ideas and make the rockets and make them work. But they haven't spent time hiring patent lawyers. They argue that that slows progress rather than advances it, and that's a counter idea to the affirmative this year. So this is from the Cato Institute in their Cato Handbook for Policymakers 20 years ago on the idea of intellectual property. They ask, and I have italics here to show these are their words, why do we protect intellectual property at all? Do we really have some property right to our intangible creations the same way we do to our homes or the land on which our homes are? And if we do have some claim to those things, are there more effective market-oriented ways of encouraging artistic creation and scientific discovery other than the use of copyright and patent law that protect this limited monopoly? That is, you're the only, Gloria was the only person who knew how to make her sauce, her family recipe, or her family was the only source. So they wanted protection for that monopoly. Nobody else could sell a sauce that tasted too much like theirs because it shows that they somehow stole the taste from her family. So these questions are hardly new, of course. They've been the debate and the scope of IP. It's centuries old. 200 years ago, these are questions that concerned the Founding Fathers, that included in the Constitution a utilitarian compromise to ensure the science of useful arts would be promoted by offering some limited protection of 14 years. So they arrived at this balancing act, and that's in Article 1, Section 8, Clause 8, which gave Congress the power to promote the progress of science and the useful arts by securing a limited time to authors and inventors exclusive rights to their respective writings and discovery. So, switching to a problem, there's many side problems, unintended consequences of granting property rights to ideas. One is the idea of pharmaceuticals. So through much effort and research, pharmaceutical companies invent or discover concoctions that they argue heal various diseases or address issues, and then they file a patent on that because they spent a lot of money trying to get approval from the FDA, but they want a patent, so they're the exclusive provider of this new drug that took them a long time and a lot of money to develop and test. Lawson Menzel here, a former high school homeschool debater, has a post for the Niskanen Center arguing on the problem of patent thickets and why do they matter. The argument here is it's true that drug companies spend a lot of money developing a drug, they get a patent with a limited length of time, but what they do to protect this patent, to increase the value of it, to lengthen the patent protection, is what's called a patent thicket. And he argues this is an anti-competitive practice that the brand name drug users do to delay the arrival of lower cost drugs. So generic drug makers, they see this new blockbuster drug that's high priced by the company that developed it, and they're waiting to reverse engineer it and offer one that is very much like it. Not identical, but they say offers the same benefits. Lawson, again, italics, showing this is drawing from his paper. A patent thicket occurs when the brand name drug maker has a portfolio of a whole bunch of overlapping patents, and they block many of the avenues of competitors who would try and provide the same medical benefit through slightly different way, and instead there's this big obstacle course and anything like this patent is going to work. And the maker says, well, we need this protection because we spent a ton of money developing this and we want protection as long as we can. The downside is that protection keeps the price higher longer, which means more people suffer and die by not having access to less expensive versions of this drug. So biosimilar competitors, low-cost versions aren't available. So you can read more about Lawson's paper on this, and you could argue that as an affirmative, IP law would be strengthened if it were focused just on the actual innovation, not on a whole bunch of obstacles against competitors. Or maybe you argue on the negative that this is a problem with current IP law, that it provides too much protection from innovation that is around the original pharmaceutical drug. So here's switching gears to another aspect of intellectual property. What happens if you didn't have intellectual property? Let's say there was a major part of innovation and development where there was no IP at all. Well, that's the story of the fashion industry. Companies spend a lot of money developing new fashions, new fabrics, new ways to sell pretty stuff, purses, clothes to the public, and they don't have IP protection. So they spend a lot of money. They have models. They have a big showing in New York of these new fashions, but they can't protect the IP. So the next day, other people can buy, very similar clothes online because other people have taken pictures of it and quickly made copycats that are much less expensive. So one interesting, and so one could argue, well, wait a minute, without IP, we can't have a fashion industry, but of course you have a fashion industry without any IP at all. And old guys like me argue against fashion in any case as a waste of money, but it's up to other people to decide how they spend their money. But it's very innovative, very fast moving. They found other ways to make money without federal IP protection. And of course they want it, but they don't get it. Now, some companies have found a way around that because you've got trademark. Even though people can copy the design of your clothes, they can't copy the trademark directly because that's considered fraud. If someone else sells a pants or a dress with the trademark of an existing company as if they are that company, that is deceiving buyers. That's a form of fraud. So one of the big companies in this field put their trademark on the outside of their purses that they sell for thousands of dollars each, and they're very well made and so forth. But they've used the stronger protection of trademarks to protect their fashion industry, that is their other products, by putting the trademark on the product. Now here's a company that tried to copy the Yves Saint Laurent trademark with their own version, and I think it's MOB instead of YL, and you can read about the story online. But Louis Vuitton, they sued this company, which was called My Other Bag, which was written on one side, and the other side has something that looks like the Louis Vuitton bag. And the judge dismissed it, said, look, it's really very different from the bag. You can tell it's not the bag. It said MOB for My Other Bag, or Mind Your Own Business, whatever it stands for. But the argument is these companies are trying to protect the value of their trademark by litigating anybody that makes a trademark that looks like it. It's a lot of money spent. Fashion's a huge industry. But the point is, without federal government protection of the fashion industry, they've still found other ways to try and protect their brand through trademark, and have litigated and so forth. So switching to copyright. So we have patents, we have trademarks, and the other part of the subject, the policy, is copyright. And as you read the history of copyrights, one of the stories is in America, even though this was listed in the Constitution, we didn't have much protection of copyrights. So novels written in Europe, would be shipped to the U.S. to sell in the U.S., and the main people at the dock to get the first copies were the American publishing companies, who would buy the book, make copies of everything, and sell their own version that looked just the same but was a copy, and they didn't pay the author, the intellectual property owner, anything. So this was the case with Dickens. Charles Dickens' novels were copied. He never got copyrights from American publishers because his right to the novels he wrote wasn't recognized in the U.S. And that's just the way it was. He made money traveling the country giving talks. He was very famous here, but he didn't make money by selling his novels because U.S. companies just copied and did it themselves. Okay, so Tom Bell writes about this in his book, Intellectual Privilege. He's skeptical of copyright law as a government privilege rather than an intellectual property right, but he talks about the common law and the common good, and he tries to find a middle ground on this. His book is available for download. You can get it from the Mercatus Institute. Tom is a professor at Chapman University in their law school there, and he writes about, and here's some of the table of contents. You can read that online. But copyright is public policy, the philosophy of it, everyday life, and I recommend it. Also, you can see him being interviewed by the Reason Foundation on intellectual property. There's a link to the video there. And you know what he says? He suggests that the U.S. should return to the kind of copyright that the founders supported, that they have in their 1790 Copyright Act. Which had 14 years. So if you're a novelist, you write a novel, you have rights to it for 14 years. You have an option to renew for another 14. But it's conditioned copyright on the satisfaction of strict statutory formalities, covered only maps, charts, and books. So it protected against unauthorized reproduction and limited remedies. So he lays out his case for that, and you can see it in his interview and in the book, which you can download. And I'm going to copy over Who Knows Who Owns Reason's interview. And then more from the book. And again, one of the benefits of this is an introduction overview of the idea of copyrights. Of course, there are many sources on this. Quick talks about the fundamental nature, its constitutional rights, relation to other legal entities. Then he turns to copyright policy and what he argues is a market failure in copyrights that aim to cure and, evaluating how they work. And then he's arguing against the background of the common law and natural rights. Where do we get our rights? How would we have a right over an idea that we wrote on paper or we wrote in a book? Where do we get rights of this against other people intruding? Or is it a claim? Is it a privilege? Or is it a right? And more, and again, you can read this on the slide, or you can go to the book and download it. But the point is, copyrights are problematic. They're not working ideally, but maybe they're better than having no rights at all. And he's trying to explain what this fair use defense would be and licensing opportunities. And again, you can read more about that. Okay, so back to intellectual property in general. Here's a post from the Adam Smith Institute and the link to the blog where you can write it. He says it's this author, Jack Coates, an unnecessary evil. Intellectual property rights, he argues, better thought of as intellectual monopoly rights, and they're unnecessary evil. And he explains in his article, and I don't need to read the text for you. You can pause and read it yourself, but this is an argument against IP. And he said, look, Dickens could make money from Americans without copyrights. Musicians could feed themselves before Edison and, recordings. Plant breeding was possible before the U.S. Plant Protection Varieties Act of 1970. We had software, top music. So he argues that all these things, they argue that IP is for promoting these intellectual production, but how much of this would work just as well without complicated and expensive IP restrictions? And that's the argument against much of the IP protection that the status quo in this topic is advocating we make even stronger. Here's another article on Adam Smith Institute in defense of intellectual property. And this is Ben Southwood, a fellow of the Institute, and he argues for a utilitarian case for patent law. He says they're good not just because, but because how they contribute to human flourishing. If you took them away, he argues, there'd be much less investment in innovation, technology, other things where the creators, the investors of this work, do it in part because they expect some sort of protection down the road once their invention or book or song is developed. Why should someone else take that value from them or diminish it by just making copies of it? So patents are, he says, like other property rights, a market mechanism for making use of decentralized information to provide incentives And they work better than prizes or other sorts of ways to promote innovation. Patents encourage information to come out in the open because you have to reveal it to get your protection. So on the one hand, it's a monopoly privilege granted by government for what you've announced that you've developed. But on the other hand, by releasing it, people can look at it and find ways maybe to innovate on that without violating your rights. So he says, look, IP can be too stringent, but maybe we've not that far yet. Maybe we should do more to protect IP. And he discusses that in his post at the link. And this is the article drawn from, and you can read more about that online. So Sheldon Richman, former editor of the Freeman, used to work at the Foundation for Economic Education where I worked. He has this article in the Dallas Morning News that's very critical of intellectual property rights. For example, he says, I articulate an idea. Other people know the idea. They can copy it in the sense because they heard it and try and explain it to others. But it doesn't diminish Sheldon's understanding of the idea. So however they use their copies, how is it an injustice to him? I'm describing Sheldon's article. I'm showing pictures of it. Am I violating rights of the Dallas Morning News because they presumably paid him to write this? Am I violating Sheldon's intellectual property because I'm just repeating his ideas and showing the text? Well, it doesn't hurt him. In fact, maybe it'll make it famous, more famous. Maybe more people will see this and say, wow, let me find out more about what that guy says, and I'll subscribe to his Substack page. Libertarian Institute, I think. In practical terms, he says, when one acquires a copyright or patent, what he acquires is not a right to his own thing, but a power to ask the government to stop other people from doing really what's harmless with their own property. How does it harm him if other people repeat what he said or what he's developed? At least that's the argument Sheldon is making. And IP advocates could say, look, they're not the same idea. I spent a lot of time developing this and you just read what I did and copied it. So that diminishes the value I can get from my idea, and you benefit from something that you spend, an hour reading, not, 5 years developing. So it's true that this sort of confuses property with economic value. But in traditional property rights theory, you own actual things. If I own a car and somebody takes it, they've taken my car without my permission, and I can't use the car. If they're driving it, I can't drive it. It's a single thing. But an idea is not like that. So we can all talk about Sheldon's article. It doesn't diminish it, the argument is. Now, you could argue there's less demand for Sheldon giving a talk on IP because we can all do that now and we all try and give talks on IP. But, that's a separate argument, and have we really taken anything from him? So more on this, and he's drawing from a book called Against Intellectual Property. And you can see the author there, and you can get a link to it, but the objection exposes what's at stake with IP, which is monopoly power granted by the state to somebody it's a privilege for a copyright or an idea. And, again, you can look at it, but that's really what's going on. And he says, let's learn more about it by looking at the history. They arose as an effort to grapple with the natural scarcity, but there's no scarcity in intellectual property. There's a scarcity in physical property like cars. History really undermines the utilitarian case, Sheldon argues, for patents and copyrights. And this is drawn from the book that he cites. For an example, James Watt's steam engine, he's the inventor of the steam engine, but what he invented wasn't very useful. He spent his time suing people for patent infringement, but it was only after people could innovate and make it better and faster and cheaper, more reliable, that it was actually valuable. And this is very much the same with the Wright brothers. So in fact, the IP protection that the government provided and Watt litigated to protect actually slowed intellectual progress. So you could argue that the utilitarian case for it is actually a case against it historically. Another book on this topic, Who Owns the Sun? A People's History of Monopoly Medicine from Aspirin to COVID-19. And he argues that patents were envisioned originally by the framers of the Constitution as a two-way social contract. We'll give you your protection as long as it advances the useful arts. But this has been turned into a vehicle of keeping vital medical knowledge private, preventing people from accessing it. And of course, the government is funding vast amounts of this research by private companies, and then they get IP protection that makes the price very high and delays it from being available for a long time. But this is the discussion. He discusses this in the 1980 Bayh-Dole Act, allowed businesses to retain the rights of knowledge developed with federal funding. And now this article was written in the early days of the COVID-19 vaccine and Operation Warp Speed, and he treats that as a success, although obviously it's criticized more as there's more pushback against unintended consequences of the various vaccines. So he argues that Trent, and this is a reviewer in Kirkus Reviews writing about this, so these aren't my words, they're from Kirkus Reviews, and I guess they can sue me if there's grounds for it, but it's argued a trenchant study of the dangers of turning medical knowledge into private intellectual property. So I recommend the book. I don't necessarily agree or know enough about it all, but he argues for the historical background. Long before medicines entered the monopoly debate, many countries were hesitant to accept even the idea of owning an idea. The debate over the legitimacy of the values of monopoly was across Europe in the 17, 18, 1900s, 20th century. Netherlands, for example, practiced a free trade in inventions to 1912. So you couldn't patent your idea, whether it was a drug or a book or anything, in Netherlands. The fiercest denunciations, the author says, of IP were in The Economist magazine, which is a free market, free trade, liberal in the classical sense publication. And again, he argues the liberals and the free traders lost the argument in the early 20th century. These patent monopolies were normalized across the industrial world. And he argues that's a mistake. But the background of this is that monopolies or patents were originally granted by the king of England or Sweden or Holland. And they were hated as privileges granted to elites, to crony capitalists, to royalty. So under Queen Elizabeth and then Parliament, they limited these rights to King James as a pushback against the patents of Queen Elizabeth. And you can sort of see this now. You can buy Royal Danish butter cookies, with the Danish royalty emblem on the, and you wonder, why is the King of Denmark in the butter cookie business? Well, because in the early days, if you had a company, you had to get royal permission for your patent, your formulation of butter cookies or marmalade. And so this was the nature of monopolies. Every company had to go to the state, to the royalty in the old order to get permission for their venture. And that's what the American Revolution and the founders were fighting against, this royal privilege. So we enjoy these great advantages from the inventions of others. Now, these were debated in the last days of the Constitutional Convention. Benjamin Franklin was very much opposed to intellectual property rights or monopoly. He was the most celebrated inventor of his time. He never applied for a patent, I think, except in one case when he was trying to forestall someone else patenting something and stopping him from producing it. Jefferson opposed patents, but he was in France at the time. So Jefferson shared Adam Smith's doubts that patents that worked. He says in a letter to a farmer, I think, he says, generally speaking, other nations have thought that these monopolies produce more embarrassment than advantage to society, and it may be observed that nations that refuse monopolies, like Switzerland and Holland, have plenty of fruitful inventions. So where's the truth in the idea that government's got to protect, shield, and promote patents? Aren't they just a privilege rather than a right? So you can read more about this. I'll also link to the online publication Who Owns Broccoli that has a number of essays, among these Terence Keeley on a history of intellectual property. And so the policy debate really rests on values. We value intellectual property rights, but why? Because it creates incentives to invest and invent. That is a utilitarian thing that leads to more economic progress and economic growth. Or do we value them because an intellectual property right is a natural right that people should own? They developed it. You know, Ayn Rand wrote Atlas Shrugged and The Fountainhead. Those were her words. So shouldn't she get the income from selling those novels to people that pay for her many years of writing it? J.R.R. Tolkien's Lord of the Rings, anybody who bought those novels in the 70s, 80s, and 90s, they often had a little notice on them that they were the official version of the author J.R.R. Tolkien, and other people were selling bootleg versions that weren't the authors, and people shouldn't buy those. But again, there was a battle over who owned the right to those novels. So the rights-based view is it was Tolkien's ideas in his mind. He owned them. He should be able to benefit from selling them. And of course, critics say he would turn over in his grave if he saw the latest Amazon version of the Rings of Power, but that's another story. But intellectual property rights is natural rights. So you have this utilitarian and natural rights conflict over this, and both these things, though, are claims. They're claims to say this is why we should protect. But what if intellectual property right claims slow economic progress? They're too strict or too loose. What if patents on immature technologies block better technologies that would better serve society? So the Wright brothers, and the discussion of this is in these essays, they had patents on their airplane. They flew the first airplane, they patented it, and no one else could fly anything similar until their patents. They spent the years after suing everybody that tried to find a plane that they felt infringed on their plane, but their plane wasn't very safe, wasn't very effective. It needed to be innovated and made better. So the critics could say IP maybe incentivized the Wright brothers to develop the plane, but it certainly had the consequence of incentivizing them to spend the next 17 years litigating competitors and blocking progress until their IP expired. Okay, so let's just stop here, and the next segment can continue. Thank you. Again, this is a presentation for the University of Scholastic League on the debate topic of strengthening intellectual property rights.